joining us for today's webinar, which is Ask Harry Live. So my name's Beth Cohen-King, and I'm the Marketing Director at Margolis & Bloom. We work with our clients to find the best estate planning or elder law solution for each client's unique situation and goals. So we bring to the effort 30 years of experience and a commitment to providing the highest level of personalized service. Today, we have a new format that we wanted to do. We wanted to reach out to you, hear your questions, and have Harry answer them live. So that's what we've done. If you aren't familiar, Harry does have a site that's called AskHarry.info, where you can submit your questions and he will answer them online, not in quite as real time as this. So if you have follow-up questions, that's a great resource. Additionally, something we'll talk about afterwards is Harry has a new book that came out. It's called Get Your Ducks in a Row, Baby Boomers Guide to Estate Planning. So big thank you to all of you who pre-ordered that already, but the book is now available on Amazon, and Harry can chime in on that as well. And additionally, if you have questions that come up while Harry is talking, please use the question panel on the right to submit, and we will follow up and try to answer those at the end. So I think now let's get started with the questions that came in previously.
Okay, that's what we'll do.
Okay.
So you asked, I'll try to answer. So question 1, regarding employing the various tricks to save your assets from the nursing home, I think I know when it might make sense to pursue these courses of action, but I'd like to know when it doesn't. On my wife's fear that I go into a nursing home, drain all of our assets, and leave nothing for her, one attorney said, if one of you goes into a nursing home, just buy an immediate annuity for the other. So there are two related questions. So the problem with a lot of long-term care planning is it really involves giving away your assets, either giving away to children outright, or more often putting them into an irrevocable trust. And the problem with an irrevocable trust is it really is a lockbox. So whatever you put in there, you can't get out. We usually put in some kind of safety hatches in case of emergency, but you really have to consider you've given the money away. We're more likely to use an irrevocable trust with a house because though you can borrow against it, in general it's not liquid. So for a lot of clients, they would want to make sure they protect the house and keep their other assets liquid and available and unprotected, so they have them to live their lives as they want to live them. We usually don't think people should sacrifice their standard of living and their freedom in retirement just because of some prospect of that they may need long-term care in the future. And the other part of this is there are usually other things to do later to protect assets, and as Peter mentions in this question, one of them is using an annuity. A spouse of a nursing home resident can protect excess assets through the use of a proper annuity. Something else some clients do is they will split their assets between them so that when one spouse dies, what's in his or her name goes into a testamentary trust for the surviving spouse. And unlike a trust you create for your own benefit and the irrevocable trust I just mentioned, this trust can be totally available to the surviving spouse and not have to be spent down for mass health eligibility. So that's something else you can set up in advance, even though it doesn't really get implemented until the first spouse dies. So I guess the answer to the question is, when does it not make sense to do advanced planning? It's really when you don't want to tie assets up. But there's still some planning you can do, such as the testamentary trust, and of course everybody should have durable powers of attorney in place just in case. I'm trying to move to the next slide, but having trouble. Oh, apparently I'm hitting the wrong button. So that's going to help here. There we go. Okay. If a Massachusetts resident dies owning a piece of New Hampshire residential real estate, for instance, a vacation house, is the New Hampshire real estate included in the decedent's estate for Massachusetts estate tax purposes? And the answer is no. So this is kind of a change. The law didn't change at all, but there was a federal case that said that that involved actually an apartment in Paris, so an out-of-country asset not includable in someone's federal estate, and by extension, that also applied to Massachusetts and out-of-state real estate. So, and so far, actually, when it happened, we had some estate tax returns recently filed or pending where we had included out-of-state property, and we asked for an abatement and got the money back. So Massachusetts honors that now. So non-Massachusetts real estate is not included in the estate of a Massachusetts resident for tax purposes. What would you recommend for a husband and wife who each want to make a gift on an annual basis of $15,000, the current gift tax exclusion, to an irrevocable trust for their 18-year-old child for the next 10 or 15 years? The funds would be invested in a tax-efficient, equity-based, exchange-traded fund for the long term. The primary goal of the trust would be future asset protection for the child. The parents have no creditor issues, and this is not a fraudulent conveyance. The trust would initially act as an emergency fund for the child, and then eventually be liquidated to provide a retirement income stream for the child. So I like the goal quite a bit. I don't like the mechanism. So this gets a little complicated. So in order to qualify for the gift tax exclusion, it has to be a completed gift to an individual. And if you transfer money to an irrevocable trust, it actually doesn't qualify for the exclusion, the gift tax exclusion. However, there is a way to get that exclusion, and it's often used in life insurance irrevocable trusts, which is a crummy power. And crummy is C-R-U-M-M-E-Y, named after a court case. And the way the crummy power works is that the beneficiary of the trust actually has the right to withdraw the money for a period of time, usually 30 days or 60 days, after the gift is transferred into the trust. The problem with that is that defeats the asset protection purpose of the trust. So it's no longer creditor protected because arguably the grantor of the trust is actually the son who chose not to fund it by choosing not to withdraw the funds. So combining the two doesn't make a lot of sense. And then the other question is, what's the purpose of doing this advanced funding? I mean, if you have, there's no, and using the gift tax exclusion. So, so I suppose over 10 years, if each spouse is putting in $15,000 a year, you have $300,000 in the trust. That's excluded from the parent's estate. If they probably don't have a federally taxable estate, with the combined limit for the two of them being $22.8 million at the moment. They may well have a Massachusetts taxable estate where the combined amount is $2 million now if you do your some kind of standard state tax planning. So reducing that by $300,000 would save some money in estate taxes, but you're talking a marginal rate of perhaps 6%. So your savings is $18,000 on 6% on $300,000, and I'm just not, to be honest, not sure it's worth the trouble. If you have an irrevocable trust, it can't be a grantor trust, which means the trust itself is going to have to file an income tax return every year. So given all of this, again, I don't know all the particulars here.
There's a follow-up.
There's a follow-up question.
Yes.
I would not be, I would probably use a different approach. So, and then continuing, does Mass law offer enough asset protection, or should the family consider another state such as Nevada? So here's the thing: you don't need to go to Nevada for a third-party trust. So a trust that you're creating for somebody else, in this case the parents are creating for the child, that's fine. It's known as a spendthrift trust. We often do in our practice what we call family protection trusts, where parents leave funds for a child or for different children, and it's designed for creditor protection, for divorce protection, even can help them qualify for public benefits if that ever becomes necessary. don't need to go out of state. Now, if you want to use the crummy powers we talked about before, then you might want to go to a state like Nevada or New Hampshire, it's a little closer, which have what are called domestic asset protection trusts, or DAPTs, and that would solve the crummy power problem that I discussed before. But again, for the amounts of money we're talking about, to be honest, I don't think it's worth the trouble. And then who would you recommend as the trustee? An aunt or uncle, along with a trust protector. The family is willing to give up a substantial amount of control for greater protection, since they would hope the child will inherit other legacy assets, qualified, non-qualified, outside the trust. Yeah, any third-party trustee would be fine. Again, whether it's established during life, as Ronald is asking, or established at death, as we would probably prefer. And it could definitely be an aunt or an uncle if you feel they're financially astute enough and responsible enough to manage the trust, and have somebody, perhaps a trust protector, who can appoint new trustees if that ever becomes necessary. And then how does the child access the money if everything goes awry and the child has future creditor problems? Well, it's entirely discretionary, so it'll be up to the trustee to choose when or how to distribute funds to the child. I mean, I'm saying it's completely discretionary. You could also put some guidelines in there for what kinds of things you would want the money spent on, guidelines or restrictions. But in our practice, we either make it totally discretionary or use some standard language for saying it's for health, education, maintenance, and support, which basically means it's not supposed to be used for frivolous items. But that's up to the grantor. Question 4. In Massachusetts, how are separate but not divorced spouses treated for mass health in the community, and is it different if applying for mass health long-term care coverage? Is having separate bank accounts and no commingled assets along with different addresses sufficient to be treated as single? So I actually dropped the ball here. I meant to talk with my partner, Patricia D'Agostino, about the community question, because to be honest, I don't know the answer, and I have a guess, but I will respond online to Linda on that question. On the long-term care coverage, at first blush, it looks like they treat the assets together, even though they're divorced, even though they're separated but not divorced. And the healthy spouse, if one spouse goes to a nursing home, is limited to about $125,000 in countable assets. However, there's a provision in the Mass Health rules for nursing home coverage, which we usually call spousal refusal or just say no, going back to Mrs. Reagan. And what the Mass Health, and this is national, so the Medicaid rules nationally say, is if there's a married couple and one spouse is in a nursing home, if the other spouse refuses to cooperate and the nursing home spouse assigns to the state his or her rights to spousal support, then they're supposed to be evaluated in terms of eligibility as if they were single. And Mass Health is supposed to refrain from asking for any information from the healthy estranged spouse. Now, in fact, the law doesn't say anything about having to be estranged, but in Massachusetts, we've only used this provision in cases where the spouses are estranged. There are some other states where they use it in other cases as well, especially New York. But in our practice, we've never had a problem when the spouses are estranged and kept their assets separately as described here, with the nursing home spouse being treated as single. In addition, we've also never had any experience of Mass Health actually using the right to spousal support or trying to enforce that against the healthy spouse. in New York State, where this is a standard practice, there have been instances, maybe it's even standard practice, that the New York Medicaid does try to enforce its rights. But here's few and far enough between that Mass Health really is not set up for that. It does take a little more work in a way, because since it's not used that much, often the Mass Health intake worker has to be educated as to what the law is and how it works. But as I said, once you've taken that step, we've never had a problem. So this is another longer question. In 2010, at the recommendation of a New Hampshire elder law attorney, my parents placed a primary home in New Hampshire in an irrevocable trust for Medicaid planning purposes. So we are beyond the look-back period. As you may know, there's a 5-year look-back period after you make a transfer, during which you cannot get Mass Health coverage. My brother and the writer are the trustees of the trust. But then the New Hampshire home was getting too much for them, and they decided they wanted to move to a warmer climate. And so the brother, the co-trustee, purchased a home in North Carolina in his name. He was really doing this until they were able to sell the New Hampshire house. And then parents moved to North Carolina. The New Hampshire house was sold. The proceeds were placed into account in the name of the irrevocable trust. And then the idea was the trust would then buy the house, the North Carolina house, from the brother, and then the North Carolina house, then the trust would hold that house. But this hasn't happened yet. So, is there a deadline? Is there a time frame for when this has to happen? The answer is no. In fact, it never has to happen. The funds, I haven't seen the trust, of course, but assuming the funds, the trust works, the funds in the trust are protected. The home in North Carolina was less expensive than the New Hampshire home, and if the excess funds, once they finally do complete this transaction, occurs, are they still protected? And the answer again is yes. Again, I'm saying this without having seen the trust. And what I would say is, if the parents are going to stay in North Carolina and are likely, if they ever need Medicaid coverage, to seek coverage in North Carolina, I would have a North Carolina attorney review the trust just to confirm that it works there. And let's see, back in 2010, the New Hampshire elder law attorney told us that New Hampshire only permits protection of the home in the trust and doesn't protect liquid assets. That's surprising to me, but I'm not a New Hampshire attorney, so I can't tell you, say anything about that. And we were recently told by the New Hampshire attorney, and the rules of New Hampshire, the trust follows those rules, even though the parents have moved to North Carolina. That's correct. And then he retired. So I would, as I said earlier, this all sounds fine, and I would just always keep good records, and I would just have it reviewed by a North Carolina attorney if that's where they may eventually seek Medicaid coverage. My 98-year-old aunt has a revocable trust funded by index funds. I believe it is a grantor trust. Any revocable trust is a grantor trust, meaning income will be taxed to the grantor. There are 2 beneficiaries, both unmarried older adults with no children. Most of the 7 reasons you mentioned to maintain a family protection trust will not be of concern, and the person is referring to a blog post at margolis.com. Feel free to check that out.
If you type that in, it'll come up on Google.
Okay. So if you type in the title, Google will find it and lead you exactly right to that particular post. Okay, next slide. So I understand that the trust reverts to being irrevocable at the aunt's passing, but I am unclear as to whether it would be a better idea to have everything distributed outright or have it remain in trust for their benefit, as your 7 Reasons article states. As you say in another article, this person's been reading, the trust will act as a pass-through with the income being taxed to the beneficiary. Then what is the advantage in this situation to keeping it as a family protection trust? Estate taxes aren't a concern, but will it be advantageous tax-wise to keep the money in a trust rather than distribute it outright? And, I'll answer those things first. So there's no tax benefit. So and there's a slight tax detriment in that you have to file a separate tax return for the trust, even though the trust will only pay taxes if the income is not distributed each year. If the income is distributed, then the income passes through to the beneficiaries. So it's not for tax purposes that you have the trust. You would have it for creditor protection purposes, as we discussed in answer to an earlier question, divorce protection, the possibility that any of the beneficiaries may need to apply for public benefits. And depending who they are, maybe you would have it in trust for fiscal management purposes. So those are all the benefits. If you don't think any of them apply, then I don't think it's worth the trouble. I would just have the trust end at the aunt's death and have everything distributed outright at that point, and everybody move on with their share and do what they want with it. So to add to my confusion, a rental agent at a high-rise building mentioned to me that some tenants qualifying for lower rents are trust beneficiaries, but that doesn't make sense to me if it's just passing through to them anyway. So there's a few issues here. So for subsidized rent, it depends on the program, but in general they look at both income and assets. So and they look at the assets in terms of qualifying in the first place, and they look at the income both for purposes of qualification and determining what share of the rent the tenant has to pay. And so if the funds are in the trust and not owned by the individual, they will not be they will not be counted in terms of the asset eligibility limits. So that's one benefit of the trust. Another potential benefit is depends in part on how the income is distributed, but in general, if the income is distributed to the beneficiary, it'll be counted for housing purposes, and as you say, as the person says, it won't make any difference in terms of eligibility. But if the trust were to hold the income, the beneficiary would not receive it, and the rent would be somewhat lower depending on the amount of the income. But if they need it, it's going to be distributed, then then the trust doesn't protect in terms of the income, but does, as I said, protect in terms of the level of assets and that eligibility limit.
Okay, so I think that's actually all for the questions that we have, but let's see if any have come in.
Looks like there's at least one.
Okay.
Okay.
A little hard to read this, but
yeah.
we will try.
For some reason, the way the panels that they give you for reading questions on this service that we're using only gives you one line at a time. So I'll read this one line at a time. I have a grandson who is autistic.
Okay. Oh, there we go.
Oh, that's better. We will be doing our estate documents shortly. We want to set up a trust for our daughter. Get the rest of that.
We want to set up a trust for our daughter.
To protect from divorce, but if something were to happen to her, we want it to go to the grandchildren, grandchild. Can we incorporate a special needs trust within the trust for a daughter? Yes, definitely.
Should our grandson's father or a sibling be the trustee? And got your book today.
Oh, thank you. So definitely you can set up a family protection trust for the daughter and have the grandson also as a beneficiary, the special needs trust. In terms of the trustee, that depends on kind of a lot of the particulars. So the kind of just who would be a good person to be trustee, who's responsible, who knows the child, who can manage the funds well, and it really could be anybody who can fill those roles, and whether it should be a family member or a professional, such as a trust officer or a bank or a lawyer or an accountant. Again, depends on who's available, and sometimes it makes sense to, if it's really to have co-trustees, because then you have the professional who's kind of can deal with all the administrative stuff, and then a family member who knows the people and knows what their needs are. And so we find that that's often a very good solution. Do you prefer a life estate versus an irrevocable trust? Pros and cons. So we talked earlier about irrevocable trusts as kind of a lockbox as a way to protect assets, including a house. A house can also be put into a life estate. One advantage of a life estate is it's a lot easier to set up. A life estate is simply a deed where you deed an interest to a third party, usually your children, while retaining the right to live there for the rest of your life. So in terms of simplicity of creating a life estate is definitely better. But in terms of, but it's also a little less flexible. And the real issue is, what would you want to do, or what would the family want to do if the life estate holder, the parents, moved out? So say mom and dad created this life estate with the remainder going to the children. The mom and dad dies, mom continues to live there, then she goes to a nursing home. The house is protected as long, in a life estate, as long as you keep it. But if you sell it, then a portion of the proceeds will go to the mom who's in the nursing home, and there are tables to figure out what percentage, and a portion will go to the children who already have an interest. They just don't have the right to possession yet. The older you are, the smaller the interest of the life estate holder, and the greater the interest of what are called the remaindermen. So that's the issue. So it makes it, there's in effect a cost to selling it in terms of some of the liquid funds going to the life tenant and having to be spent on her care, have to be spent down before she's eligible for Medicaid. And maybe that's fine, or you figure since the majority will be protected, that's fine. Another issue with a life estate is it is a co-ownership arrangement where the life tenant owns a piece and the remaindermen own a piece. So if you want to sell it, everybody has to be in agreement, or else you have to go to court in a partition action. And if it's a trust, only the trustees have to decide what to do. So I think in most cases, we prefer an irrevocable trust, just because it's more flexible. You have one or two trustees in charge. If it's sold, the proceeds are protected. You're also probably better off in terms of capital gains. The $250,000 exclusion on the sale of real estate will apply if the trust is properly drafted, will be available. In a life estate, it will apply to the parent's share, but not to the remainder share. They'll have to pay tax on capital gains. So that's another advantage of the trust. Where I see the life estate as having a clear advantage is where you're not sure that the person is going to make it 5 years, because it's a 5-year penalty for creating either one, and there's not enough money left outside of the trust to pay for 5 years of care. In that case, one benefit of the life estate is it's reversible. So let's say I give my kids remainder interest in my house, I keep a life interest, and then 2 years later I go to a nursing home and I don't have enough money to pay for 3 years of care in a nursing home. And because I made the transfer, I can't get Mass Health for 3 years. In that case, the children, if it's a life estate, can just convey their interest back to me. And Mass Health treats it as what we call a cure, as if it never happened. And so then I can get Mass Health, because you're allowed to keep your home and get Mass Health. They will put a lien on it, but I have not protected the house by doing this, but I also haven't put myself into a really difficult situation of needing 3 years of care and not having any way to pay for it. So in those cases, we may be more likely to use a life estate.
Okay, another one.
Okay, please talk more about family protection trusts. So I more or less covered it, but the idea of a family protection trust is, rather than giving funds at death outright to a beneficiary, they're in trust for the beneficiary. And there are a range of ways to draft these trusts, and the general rule is the more restrictive the trust is, the more protective it is. So nothing is necessarily 100% foolproof, because judges can kind of do what they want. But in general, the most foolproof way to do the trust is to make the distributions entirely discretionary to the trustee, and having an independent third-party trustee, such as a bank or trust company. That trust is, 99-point-something% of the time, will be protected from the creditors of the beneficiary, and will be protected if the beneficiary is divorced. Now, a lot of our clients don't want a professional trustee, both because they don't want to give up control, and also because they don't want to pay anybody for that service. So we often do trusts where the beneficiary himself or herself is the trustee, so they can manage the funds. They're entitled to the income of the trust under the way we draft it, so they can receive dividends and interest of what's invested, but they can't dip into the principal themselves. So then at a later date, if they need access to principal, then they have to appoint an independent trustee. But up until that point, they can manage the funds themselves. And we think this works. It's maybe not quite as foolproof as the first approach, but it's more acceptable to our clients who would rather not have a professional trustee involved, and would allow their child, would want their child to have some control while this is going, until they need the funds. And then the children are supposed to think of this as really a reserve fund. It's not something they're going to be living on, but it's there in case they ever need it in the future, so they shouldn't dip into it. The Achilles heel of this approach is that it's working depends on the child following the rules. Because as a practical matter, if the child dips into the principal, no one's going to stop him or her. They're the trustee, the bank or the financial institution is going to honor what they say to do as trustee. But once they do that, they've lost all the protection of the trust, because if they ever got sued or had a divorce proceeding, the other side, the adversary, was going to ask how they've used the trust, and they're going to see that they're using the principal, and then they'll say, well, it doesn't matter what the trust says, you're treating it as your own piggy bank. So they have to follow the rules. But still, most of our clients prefer that approach just because of the flexibility.
Okay, so it looks like maybe I missed a question that somebody had sent in, so we can answer that now. Sorry if I missed that.
Okay.
But this is on...
Let's see. I was asking about capital gains taxes on a home and what... Sorry, everybody. Looks like there are a lot of questions we're having trouble. Looking at here.
See it all.
Uh-huh.
I was asking about capital gains taxes on a home and what alternatives there are if they are so huge you can't stomach it.
Oh. So when you sell property, you may or may not have capital gain. If you do, it's taxed, and depending on your income, it could be taxed as much as 20% federally, and plus another 5% or so in Massachusetts. So you could have a quarter of the tax in capital gain, and the capital gain is the difference between the basis and the selling price. And the basis is what you paid for it. So if you bought a house for $200,000 and you sell it for $500,000, the gain is $300,000. However, the basis may be adjusted in a couple of ways. First, if you made capital improvements to the house, those get added to the basis. So if you bought the house for $200,000, but you made $50,000 of capital improvement, then the basis gets increased to $250,000. In addition, if someone owning a house dies and it passes to someone else, the basis gets adjusted to the value on the date of death. So then if somebody dies and their basis was $200,000, but it was worth $500,000 when they died, the basis becomes $500,000. So the heirs who are selling it, they have no tax. But if they sell for $500,000, there's no capital gains and there's no tax. Finally, if you're selling your own home, you can exclude the first $250,000 of gain, and if it's a couple, they exclude $500,000 of gain. But let's say you bought a house in the right neighborhood 40 years ago for $200,000, and now it's worth $1.5 million. And so even if you exclude $500,000 of gain, you've got $800,000 of gain remaining. And the tax on that, if it's a quarter, that's $200,000. That's a lot of tax. So what do you do about it? So I mean, there's some possibilities. None of them might be great. If it's rental property, then you can do a like-kind exchange for other property of similar value. So you could move out and rent it out for a while, for long enough to turn into commercial property, and do that, and then you can postpone any gain. Or you could not sell it, you could borrow against it. So if you're selling it because you want the cash, you could get a loan on it and use that money to buy a new place, and then you're not selling it, so you have no gain. You could do a combination of the two. You could move out, start renting it out, and also borrow against it. And then you not only you get there are other tax advantages to owning rental real estate. So you can depreciate it. You can deduct various costs, including interest payments on the loan, as business expenses. But those are probably the main things. Basically, they all involve turning it into, well, one is just a loan, but if it's empty, you probably still want to rent it out. So in effect, it means turning it into rental property. But if you don't want that headache, then maybe you should just, and you don't want to wait until you die to sell it, you may want to just sell and take your lumps in terms of taxes.
Okay.
So.
And can you?
How many more questions do we have?
I think there's one or two more.
Okay, I'll try to be quick.
Okay. Can you say more about a trust not distributing all of the income? Is that determined by the trustee?
So it depends on the trust. So some trusts say that all the income has to be distributed. That's true of what's called a Q-tip trust, which is a kind of trust that's often used for estate tax planning with spouses. So if you leave a trust, a Q-tip trust for your spouse, it has to distribute all the income. But if it's discretionary, it's up to the trustee. So the trustee can distribute it or not, and can consider the needs of the beneficiary and the tax implications of holding it in the trust and the trust paying the tax versus distributing it and the beneficiary paying the tax. In general, when the trust has income and it does make distributions, kind of the first dollars out are considered to be income rather than principal. So if you have a trust, just by way of example, that earns $10,000 in a year in income, and let's say that's the income after any deductions available to the trust, and distributes $100,000 during that year, that first $10,000 will be considered taxable income to the beneficiary, and the next $90,000 will not be considered income. It will be just a distribution of principal and will not be taxed to the beneficiary.
Okay, I think this is the last one I can see here, but can Harry please comment on the new IRA distribution rules under consideration by Congress?
So as I understand it, those would require that inherited IRAs be distributed within 5 years of the date of death of the beneficiary, rather than the way it works now, where you can stretch the distributions out during the lifetime of the ultimate beneficiary. And I can see why it's a disadvantage to people inheriting IRAs, but would also simplify things a lot. So we go through a lot of trouble, especially when IRAs are going to trusts, to draft the trusts so that they are deemed qualified beneficiaries and can stretch out the IRA payments so they're not forced into making the withdrawals and paying the taxes within 5 years. If that option were unavailable, it would certainly make our trust a lot easier to draft, and the whole thing a lot easier to manage. So, I as a policy matter, to be honest, I don't have a strong feeling one way or the other. But as a practical matter, I think it would make our lives a lot easier.
Okay, so there may be a few more in there, but we're
and if there are, we'll answer them at AskHarry.info.
Yes. So thank you so much, Harry. Thanks to all of you for listening. I know asset protection and life can be very, very complicated and a little hairy, so no pun intended. So thank you for clarifying and helping to simplify everything. So you can see there's the follow-up book that we spoke about earlier, Get Your Ducks in a Row. And this is available on Amazon, and you can link to it from our margolis.com, Get Your Ducks in a Row.
So do you have to put those hyphens in?
You can, yes. Or I'm actually not sure if you do, but you can just scroll to our page, go under resources, and it's right there in a drop-down menu. And we are going to have a recording of the presentation because I know there's a lot of information in here. So we will have that within the next week or so you can follow up and parse through what makes sense for you or pass it along to other family members or colleagues. So look out for that in the next week or so and check your email. And then please see our additional contact information, and hope you enjoy the rest of your day. Thanks.
And we have another webinar coming up next month, right?
We do.
Sarah.
Yes, we do. With one of the other attorneys here. We don't have the working title yet. So,
okay.
But that's going to be July 25th.
Okay.
And you'll get information on that in the newsletter and a separate email as well.